Hello, welcome to Workplace Wake Up. I'm Jen Shaw. Every week, I spend about 15 minutes covering key legal developments, introducing you to interesting guests, and providing some entertainment to start your workday. I hope you enjoyed this week's episode. I cannot believe we're in the middle of November. This year is almost over. This year has gone more quickly for me than any other year, I think, in a very long time. So I cannot believe we're almost at the end. This is nuts. But at the end of the year, we always get the legislature here in California who gives us new laws. And these folks are very busy all year in committee and looking at what laws, what protections need to be put in place. And around the middle of October, we usually get the final list. The governor decides whether or not to sign. And by this time, we are preparing our legal update. Now, as all of you know, we do these legal updates every year. I think this is our 24th one in a row that we are doing. We have various dates. You can register on the website. But what I want to do here in the podcast is just give you a little overview of the main new laws for 2025 that we want you to be thinking about. And that way you'll at least know what you need to be pondering and preparing for going into January. So the first thing is, of course, California's minimum wage is going up starting January 1. It's going to be $16.50 per hour. There is a proposition on the ballot, though, Proposition 32, that will result in the minimum wage actually going up to $17 per hour for employers with 26 or more employees and $18 an hour in January 2025. So it would be an immediate increase for the rest of 2024 for those larger employers. So definitely keep your eye on that. Also related to minimum wage is the healthcare minimum wage. Remember, that was delayed this year. The new law actually took effect on October 16th, 2024. So if you are a healthcare employer, you need to take a look at the healthcare minimum wage law and make sure you are complying. We also have some developments in the leave of absence area. AB 2499, it expands jury and witness duty leave as well as crime victim leave. It's actually interesting. It takes it from the labor code to the California Fair Employment and Housing Act, which means that the California Civil Rights Department is now going to be responsible for enforcing these laws. The jury and witness duty basically is going to be the same, but the crime victim leave is expanding. For example, if you have 25 or more employees, you still are going to have to provide time off for crime victims for treatment and other purposes, but you're also going to be able to take time off to help a family member. We also have SB 1105, which expands California's paid sick leave. It allows agricultural employees to use paid sick leave to avoid natural disaster type of situations or even just climate change issues. So smoke, heat, flooding, etc. If there's a local or state emergency. Also, AB 2123, this law changes California's paid family leave. It eliminates the employer's ability to require an employee to use 2 weeks of their vacation or PTO as a condition of receiving paid family leave benefits. Remember, folks, that paid family leave is actually not leave, right? Paid family leave is a benefit. It's a wage replacement benefit. It's really the flip side of state disability insurance. So you get SDI if you are unable to work because of your own illness or injury. You get paid family leave if your family member's illness or injury. So we talk about it in the leave of absence area just because people think of it as a leave, but it's really not a leave. It's just a benefit that is provided through the state employment development department. We also have some equal employment opportunity developments. SB 399 is actually interesting. It's more of a labor relations law, frankly. We're considering it sort of EEO related because it talks about what types of protections are available for employees. But what this new law does is says that you cannot, as an employer, you cannot require an employee to participate in a meeting that you sponsor relating to your opinion on political issues, religious issues, or union issues. So in other words, you can't have a mandatory employee meeting, even if you pay them for the meeting, where you're going to talk about your politics or what's more likely your thoughts about having a union in the workplace. So that's going to be a big deal for union organizing. If you're on the employer side and you're trying to prevent the union, you're going to have to be really careful how you handle those meetings. Also, we have SB 1100. There has been a long trend here in California regarding what employers can ask on employment applications and during interviews. SB 1100 says you cannot require an applicant to have a driver's license unless it's going to be an essential function of the job. And it's not really feasible to use alternative transportation like a bus or an Uber. Also, SB 1137 relates to equal employment opportunity in terms of protected characteristics, saying that an employee can sue for discrimination, for example, if there was discrimination they believe on a combination of characteristics, not just race, for example, or sex, but a combination of things. So when you look at workplace safety, there are a couple things. First of all, AB 2975 requires the board to revise the workplace violence prevention program requirements that are in the healthcare regulations to include a requirement that the hospital implement a weapons screening detection policy. That's a big deal. That is not in effect until March of 2027. Also, by December 2027, AB 1976 directs the board to submit a rulemaking proposal to deal with medication antagonists that can deal with opioid overdoses. So obviously a very important issue, and to include those in first aid materials. There are also some existing directives from Cal OSHA that apply in 2024 regarding the indoor and outdoor heat illness prevention regulations. By the way, this is actually federal OSHA, so this is going to apply throughout the country. And then Cal OSHA is, of course, expected to make some similar changes as we go through 2025. A lot of times these issues are, they start on a national level when it comes to health and safety, and then California jumps in. There are also, with respect to independent contractors, there are some new rules regarding freelance workers. As you know, the independent contractor rules have recently become very, very tough to meet if you're trying to establish a relationship with an independent contractor. So you need to keep an eye on what's going on in terms of recognizing that intent is not the important issue when it comes to whether folks can be independent contractors, right? So just remember, folks, there are a number of requirements that come into play when we're talking about independent contractors. And we're still getting a ton of clients who are getting sued for this because they just can't come to terms with the fact that most of the time, you are not going to be able to have an independent contractor, even if they only come once a year, even if they only do a very limited number of things for you. There, of course, have been some PAGA reforms this year that have already gone into play, but they are going to be very important for you for 2025. The penalties for PAGA are significantly reduced if you have done audits, if you have reviewed your policies and practices to make sure you're in compliance. So there should definitely be on your to-do list for 2025, looking at all of your wage hour practices and making sure that you are very clear about where your potential risks are. Now, again, I don't judge people for not complying. If you decide you're just not going to comply with a particular rule, you're going to take the risk, totally fine, no judgment. There are smart approaches you can take to that, though. You don't necessarily want to spell it out in your employee handbook, as Julia in our office mentioned last week on the podcast. You don't necessarily want to spell that out, right? Oh, by the way, we're not going to let you leave the premises for your rest breaks. Well, California law doesn't allow you to do that. If you're worried about safety and you're going to keep folks in during their rest breaks and they're going to be paid, but you don't want them leaving the premises because you're worried about safety, don't advertise it in the handbook. So there are approaches and strategies you can use to comply with all these new laws. There's also this very interesting new law, which is Assembly Bill 3234. It already went into effect in September of 2024. And it talks about voluntary, non-governmental social compliance audits. And the law is very interesting in terms of what is a social compliance audit. So it mainly relates to hiring of minors and making sure that you are following the rules regarding when minors can work, what jobs they can do, how to keep them safe. But it's a very interesting concept, voluntary social compliance audit. So take a look at that because it's very interesting. And you are going to be required to publicly share the results of that kind of an audit. This is why when you do a wage hour audit or an HR audit, we always recommend you do it with counsel because it is then privileged and it cannot be disclosed. So there are some interesting things out there. There are a lot of laws that the governor vetoed. I'm not going to go into them because, hey, we don't have to worry about them. We've got enough on our plates, right? So just remember, folks, when these new laws come into play, you've got to change handbooks. You got to train people. You've got to make sure that everybody understands what is going on. And that starts with HR. That starts with whoever is handling HR in your organization. You may be the owner and you handle HR. You may have an HR department of 50, depending on how big you are and where you do business. The bottom line is HR has to get a jump on these issues as soon as you possibly can, because you're going to have to think through every iteration in your organization of how these laws come into play, what you're going to do to avoid liability, how you're going to strategize to make sure that everybody knows what the requirements are without actually giving them a roadmap for how to sue you, right? So we have to think very strategically when it comes to the new legislation. There's also federal legislation that we'll talk about at the legal update. The other thing we do at the legal update presentation, of course, is talk about case law. So we're going to get into all the new court decisions, what you need to know about them regarding employee travel, regarding rounding practices for timekeeping. So many important cases, non-competes and non-solicitation agreements. There's a lot to look at for 2025. So make sure you go on our website, register if you haven't already for that employee handbook update that Julie is going to do, which is a great session. We do it every year. And then we have a number of options for you to take the legal update session. Remember, these are live session, folks. You can ask as many questions as you want, and we will get you those answers. So I hope to see all of you soon. Have a great day. And it's beautiful fall weather here in Sacramento. So I hope wherever you are, you can go out and enjoy yourselves. I'll see you next time. Workplace Wake Up, including our guests and hosts, do not provide legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction. If you enjoyed this episode and would like to spread the word, please share it with others. Post about it on social media and/or rate and review it. You can also follow us on LinkedIn, Twitter, and Facebook, and email us at info@shawlawgroup.com.